Everyone, I really appreciate you coming out tonight to listen to Pete's webinar. So tonight the presentation is being brought to you by BSG. BSG offers a scalable turnkey operations solution for small to mid-sized hardware companies looking to take innovative products from DFM to fully qualified products shipped to your warehouse. So they're your satellite office and team on the ground in Shenzhen for production readiness, factory selection, supply chain management, and quality control. BSG is the faster, simpler, safer path to manufacturing. You can go ahead and download their free go-to manufacturing checklist. I'll be putting that here in the chat box if everyone wants to go ahead and check that out when they have a second later on. It's right there on the chat box. Go ahead and check that out in your spare time. Additionally, Hardware Massive also has launched a brand new pilot version of their new virtual accelerator called Elevate. The Elevate program is a 2-, 4-, and 10-week program designed to help startups make a plan, identify key hurdles, raise money, build a network, and execute. For more information about this pilot program or to hear pricing, please contact me, Matt. I'm going to put my email address in here, and I can send you guys off a little quick intro deck to give you more information about that pilot program we're going to be launching here soon. There's my email address. Go ahead and shoot me an email if you want to learn more about that program. So now for tonight's webinar presentation, we have Pete Tormey, the managing partner of Antero, Tormey, and Peregrine. I hope I said that right. He will be presenting on early stage protection of intellectual property. We will have a 15-minute Q&A session at the end of the webinar, and you will be prompted to fill in your question on screen when the time comes. Additionally, tonight's webinar will also be recorded and released within 2 weeks on our Resource Center. So make sure to look out for that email in the next couple of weeks. Yeah, so without further ado, I'm going to go ahead and let Pete take the floor and begin this presentation.
All right, thanks a lot, Matt. Thanks for the whole Hardware Massive community. It's always fun going to your meetups and learning what you have to offer. So let me tell you a little bit about myself before we get started. I was a product designer for years, kind of left the engineering world and went into marketing. And then in the 90s, I started my own software company. In fact, I was doing mobile app development on Palm Pilots, if anyone's old enough to remember those. Anyhow, Palm Pilots went away, and I ended up consulting for a lot of other startup people and decided I liked to patent the intellectual property side of the startup world and specialize just on that. So what happens is when I talk about intellectual property protection, I talk about it from my own business experience and my own business, the way I look at it, as much a businessman as I do as a lawyer. And you'll see that hopefully as we go through the presentation, because after all, that's what we're about. Intellectual property is hopefully to help our business. So one quick introductory note, if I can get my slide to change here, is a topic I call dealing with lawyers. Fundamentally, entrepreneurs, if you're starting a business, your job is to take risk. That's what you get paid for. A lawyer can help you manage that risk. It's a mistake, I think, for some startups to assume that a lawyer or a CPA or any professional knows a lot about their business. Basically, we can manage the risk, do what we do professionally, but you as the entrepreneur need to value that and decide if the risk is worth taking or not. Lawyers live in a climate of fear. You know, we go to law school and we study case after case of everything that went wrong. And even though a lawyer might say, don't do this or do that, you as an entrepreneur, it's perfectly legitimate to say, what happens if I do? You know, because you're going to take the risk. And we can manage to say, okay, if you're going to do that, do it this way, and that'll help you minimize the risk. So the takeaway here is don't put too much faith in a lawyer's idea to tell you how your market should be. That's really what your job is, and you need to manage that risk. Okay, get that out of the way. Legal protection in the intellectual property world. The first concept to keep in mind is that we don't protect ideas. We protect expressions of those ideas. So it's not a question of do you have an idea of a love story, a boy meets a girl and their families hate each other and the kids end up dead. It's your expression when you give the boy a name Romeo and you give the girl a name Juliet. And then you start making the expression of what they say. You know, wherefore art thou Romeo? So it's not the concept or idea you have that the law protects. It's how you manifest that idea. So you can have many different ways to do similar products, and people do. Second note I have down here on this slide, there's a rumor out there that you can protect yourself somehow by writing it down and mailing it to yourself. So I put a little bullet on this slide to tell people that will give you no protection at all. In fact, I was at a party once and this person had addressed several envelopes to themselves and didn't seal them. And then it was a sports event, and they actually came out with a sealed envelope predicting what the winner will be, who the winner will be. Well, of course, mailing a letter to yourself doesn't get you anywhere. So don't do it. It's a bad idea. So just a couple things before we get into the world of legal protection. Next, intellectual property is a business. And the best way to think about it is to think about your sustainable competitive advantage. And what I mean is something that your company does, your product, your service, that gives you a major advantage over your competition, and you can keep it for a long time. And of course, usually you see this paraphrased as, does it make it faster, better, or less expensive? Faster, better, cheaper, you hear quite a bit. The test I use is, how would you feel if your competition started doing it? And if it makes you uncomfortable, then that's exactly the type of sustainable competitive advantage you want to own and you want to protect. So IP, intellectual property, is only one form of what can be a sustainable competitive advantage. Obviously, have money, that's a good advantage, a competitive advantage. A good network, lower cost manufacturing, or a way to market, or a crack sales force, or something along those lines gives you other sustainable competitive advantages. But intellectual property is one of them, and that's what we're going to focus on today. The basic forms of IP are trade secret, copyright, trademark, and patents. And real briefly, to sort them out, a trade secret is your secret sauce, what you know that other people do not know. Copyright is more protection for, well, we think of it as a printed word, but really it's for music, art, song lyrics, things like that, photography. The next topic is trademark, and this is very important for us, names and logos, and we'll spend a lot of time on trademark later on. But notice the difference between a trademark and a patent. A patent is generally for a thing or a business method, either a process or a new piece of hardware, some new device or tool or something you invented. And people often confuse trademark and patents, probably just not knowing the difference between the two very well. So when we talk about trademarks, we're talking about your branding fundamentally, and we're talking about patents, we're talking about your product or your service. I threw a slide in here on non-disclosure agreements. Often when we meet people at this stage, they're at the very early beginning of their business, and they have to tell somebody they need some kind of help. And so when you're first starting off, you can use a non-disclosure agreement. In fact, you can download them. There's plenty of them out there. You don't have to have a lot in a non-disclosure agreement. Generally, shorter is better. But the important thing is you should spell out in your non-disclosure agreement what it is that you're claiming as a secret. Enough details so that the court can do something with it. If you have a very broad definition, you know, my new golf idea or something like that, a court's going to have a hard time deciding whether that's even enforceable because it's too, it's not specific enough. So if you have a non-disclosure agreement, make sure that you write out what it is you're disclosing that you're expecting to keep a secret. Now, the shorter the agreement, the easier it's going to be to get them signed. If somebody hands you 5 pages and say, sign this, there's going to be a real reluctance, and you're trying to build a team early on. So there's kind of a reluctance to sign non-disclosure agreements. In fact, investors generally will not sign them. And the reason is they see a lot of opportunities, and they don't want to make themselves liable to everybody who shows up with a non-disclosure agreement. Usually they'll tell you something like, file for a patent on it, and then come back, you know, and then you have your invention protected. But anyhow, the rule for non-disclosure agreements is you can use them very early on, be very specific, and as you're starting your new idea or wherever you're going with your business, they might come in handy. They're a little hard to enforce because you're not always sure how your secret got out. I mean, it's very hard to track if someone discloses a secret. But enough about non-disclosure agreements. Let's get into some more secrets. Trade secrets are a protectable form of intellectual property. The courts will enforce them. If you have something that's actually a secret, like Coca-Cola, like the recipe for Coca-Cola, the recipe for Famous Amos cookies, those are the ones that we know publicly. But there are actually quite a bit of trade secrets out there in manufacturing, like how to make something. I worked with a company, and they had a very unique way to apply Peltier coolers to a piece of copper. And only a few people actually knew how to do it. And that was one of their trade secrets. So all along the manufacturing process, all along your business process, you're likely to run into things that you want to keep a secret. So what is a secret? Any formula, practice, process, compilation of information, or anything generally not known to the public that gives your business an economic advantage. So you may have a unique way to find potential clients or a unique way to handle your billing that makes you a little more money than maybe your competitor does. So trade secrets can be customer or prospect information, sales techniques, financing, of course, pre-patent information you're going to patent, things like that, software techniques. They can all be trade secrets. The trick to getting a trade secret is to treat it like it's a secret. It's the easiest of all the intellectual property forms to have, because if you treat it like a guarded secret, like the recipe for Coke, the courts will respect that. So what that means is that you don't give it to anyone who does not have a need to know. And so you only disclose it to the people who need to know it and nobody else. They say the recipe for Coca-Cola is locked up in a safe somewhere and only 6 people know what it is. I don't know how true that is. It's probably more urban legend than anything else. But it's a good example of how to treat your trade secrets. If you want the court to respect them, you need to respect them as a secret as well. So the courts will enforce them, and by doing that, they do 2 really nice things for startup companies. The first is they will let you stop an employee from telling their new company about it. So you can actually go after that employee to not tell, or if you think they disclosed, go after that company and stop them from using the secret information. So you literally can get a court order, go in there and say, you're not allowed to use this information. Even though they know about it, the courts will back you up on it. And many people probably have signed employment agreements that say you are not bringing over any secret information into our company. And the reason they do that is because they don't want to end up on the bad side of a court order, meddling in their business and costing them a lot of money in order to protect a trade secret. Most companies are quite happy with their own secret and they aren't looking for other secrets. But it is enforceable and it's very affordable because all you have to do is treat it like it's a trade secret. Don't disclose your secret to anyone unless it's absolutely necessary. And that includes investors. I had a lawyer once brag to me that he will get their early stage investors on the stand and ask them about the trade secrets. And if they know, if you think about it for a second, investors don't really need to know the secret, how you got there. What investors want to see is the results. Can you actually do what you claim you can do? But they don't need to know how you do it. That's proprietary information that you want to keep for the company. So I had a lawyer explain to me that that's how one way they go after trade secrets. So the higher standard that you put on the trade secret, the easier it will be for you to protect later on, and you'll be able to keep control of that, and that becomes part of your company's sustainable competitive advantage, right, in the long run. Certainly the recipe for Coca-Cola has been part of the folklore, part of the brand, and part of the image of Coca-Cola, the product, and all their associated products that go with it. So that's enough about trade secrets. Let's get into something a little more interesting, which is copyrights. Copyrights are interesting. They belong to the person as soon as the person sets down in a tangible form what their creative idea is. You'll notice at the very bottom of the slide, I have a copyright notice on my PowerPoint presentation. As soon as I write that PowerPoint presentation, I own the copyright, whether I mark it with a copyright or not. What marking the copyright does is it tells the world, hey, this information is copyrighted, and you're subject to some legal action if you copy it. So the copyright notice at the bottom, all it does is put the world on notice. You own it as soon as you set it in tangible form. If you're a photographer and you take a picture, you have a copyright on that picture. If you're an artist or a songwriter or anything like that, you own it. Copyrights are registerable, and actually what you register them with is the Library of Congress. And it's very easy to do because you can just go to copyright.gov and upload the copyright, the material, and pay a fee. I think it's like $65 last time I looked. You don't have to register a copyright in order to make it enforceable. It's enforceable simply because you have it. You did it, you're the originator of it, and you're entitled to enforce it in court. The only problem is if you don't register your copyright, when you go to enforce it, the courts most likely all will do is make the copier stop, and they may give you lost profits. So you don't get a lot of damages. If you have something like a photograph, somebody sticks it on their webpage and you want to go after them for copyright infringement, all you're probably going to get is a court order. Well, it turns out that if you register your creative work with the Copyright Office, when you sue the infringer, you can get damages, what they call statutory damages. So up to $150,000 in infringement. And here's how this changes the calculus for you as a business person. If you go after somebody that copies your work, you go to your lawyer and say, yeah, we can make him stop. We can go to court, we can get a court order and make him stop. Maybe we'll get back some of the profit. If you come to your lawyer and say, listen, they're copywriting and we have registered it with the Copyright Office and we're entitled to actual damages, well, now there's a pot of gold at the end of the rainbow. But a lot easier to get a lawyer to do it because there'll be money to pay for the lawyer when it's over and maybe some money for yourself. So it's well worth taking the time to register your copyright if you have anything that you think is really going to be valuable and copyable, if it's something that's important to your business. I have a copyright notice on this presentation. I'm highly unlikely to ever go after anybody on copyright infringement with it. But I put the notice on there because I'm giving the presentation and I want you to see it. In your business, have some policies about copyright notices. When you can use it, have employment agreements that transfer copyrighted material to your company. We were involved in a very detailed lawsuit where one of the co-founders of the company, they never had a writing where the co-founder gave her source code to the company. She was a contract, well, I guess there's a little bit of debate whether she was a contract employee or actually a co-founder. So when she had a falling out with the other co-founder, she went to court and said, I own all this material, it's my copyright. And on paper she did. There was no writing transferring the copyright to the company. So on paper she did. Now there's things you can do in court, but that's a bad way to start a business, especially in the early stage, having a lawsuit over who owns the copyright to your source code. So you want to make sure you have an agreement with all the players on your team that transfer all their intellectual property, specifically any copyrighted material, to your company. Have a policy for others' protected works. We had a case where a company, a small firm, had just pulled some pictures off the internet and used them on their webpage. And they got a cease and desist letter. Give us $10,000 and we're not going to sue you. And, of course, it costs more than $10,000 to defend against the lawsuit. And it's kind of a loser situation where it's cheaper to pay the person off. But they had copied the material, legitimately copied. They really did copy it. So they were at risk because they infringed on their copyright and they had every right to be subject to a lawsuit. And of course, in that case, we negotiated our way out of it. But even then, you don't want your employees or people from your company to go out and start using material from the web. So if you're a web developer, if you're having a web page done, make sure your web developer gives you title to all the artwork they use so you don't have a problem. I think modernly web developers know to do this, but you want to make sure you do it anyhow. A lot of you are familiar with open source rights, IP licensing agreement, employee training. When you get into a little more detail about what you're doing with your IP strategy, you want to make sure you keep copyrights in mind as you go through that. So, a couple things I've already mentioned. Don't let your employees grab images off the web. There are some great websites out there with stock photos and images, pretty much everything you want nowadays. You can just do a keyword search on it and buy it, and you buy it for a couple bucks. So it's easy to just grab whatever images you need and use them. Make sure you have the employees transfer their rights in their employment contract. And if you have a contractor in particular, make sure that the contractor assigns all their rights because they actually have more legal rights than an employee. Usually you can argue with an employee they should transfer the copyrights to you. If they're independent contractors, they may want to keep those copyrights to themselves. Now, copyrights are more than just the words, for software. It's actually a bundle of rights. The right to use, the right to copy, the right to resell, the right to import, and things like that. So you want a very broad copyright transfer between your employees and your contractors over to your company. So any standard startup kind of lawyer would be able to prepare that document for you with your early stage employees. Here's a little something fun to do with copyrights. If you ever get a chance, this is a little bit old, but this is Google's terms of service on that free Gmail account. Or at least it was several years ago. I don't know if it still is there. But it says, by submitting, posting, or displaying the content, you give Google a perpetual, irrevocable, worldwide, royalty-free, and non-exclusive license to reproduce, adapt, modify, translate, publish, publicly perform, publicly display, and distribute any content which you submit, post, or display on or through the services. This is a very broad transfer of copyright to Google, and all you have to do is use their Gmail service to do it. Needless to say, when we get clients and they use a Gmail account and they're sending us their patent information or some information that you don't want made public, we have to tell them maybe you shouldn't be using the free Gmail service. I think the paid Gmail service has more privacy rights, and this may have changed over time, but when I pulled it off, this is what it was. So you may be giving up your copyrights inadvertently, just in the regular process of doing business. So you want to watch out for that. Maybe have some more secure way to deal with more sensitive information. The next topic is trademarks. So a trademark is some indication used to identify the commercial source of goods or services. So it's not really a product name, it's the name of the source of the product. So it's, Ford automobiles versus, General Motors automobiles or something along those lines. So it tells the public, trademark laws are very primitive, it's a very old law, way to tell the public about the source of the goods and materials so that you as a consumer have some protection and you know that you're buying good stuff. I think the story goes way back hundreds of years ago. There was a sword maker who made great swords, and then a sword maker who made terrible swords signed the good sword maker's name to the swords. So people didn't know if they were getting good swords or bad swords. Needless to say, they went to battle, the bad swords failed, the king had a lot to say about it. And that was the very beginning of trademark law. You can't sign your name on, you can't sign someone else's name on your work. And if you sign your work, it's protected. So the idea is to protect the consumers so that they know that the product or service they're buying comes from that supplier. So as far as a business is concerned, products change over time. I remember when Nike first entered the market, they had a waffle tennis shoe. It was interesting because when you ran with the waffle tennis shoe, it left an imprint in the dirt of a waffle shape. And everybody walking along behind it would say, hey, look, that tennis shoe looks different. Well, over time, the patent on that tennis shoe expired, and what was left was the Nike brand, the Nike swoosh, the Nike name. And that became the most valuable piece of intellectual property they could get. Way more value than the patent on the tennis shoe. So trademark registration protects your brand name against dilution. That means everyone else using it to the point where it no longer identifies your company as the source of the product or service, or other misuse, right? Similar brand names and logos and things like that. Trademarking also allows you to stop the importation of knockoff goods. Every now and again you'll read articles about knockoff Gucci purses being stopped at customs and immigration. And if you're a hardware massive customer, you're likely to be having products made overseas, shipping into the U.S. And if there's a knockoff coming in, you'd like to have the trademark protection so that you can customs and immigration to stop letting that knockoff product come in. So registration provides you that. And it can help you keep an internet domain because the internet domain law ties domain name and trademark together, which only makes sense. So let's talk about different types of candidates for trademarks. The first thing you need to know is that trademarks are industry specific. That means you can have two identical trademarks in two completely different industries. And most people are familiar with Pandora Music. Not everybody's familiar with Pandora Jewelry, but the exact same name, Pandora, in the music industry and the jewelry industry. And the reason is if you download a Pandora app and you're listening to music, you're not likely to confuse that with a jewelry manufacturer. So you're allowed to do that. Trademarks are industry specific, which is why you'll see the same mark in many different places. Here are some good ways to make strong trademarks, which is what you're after. The best way, in my mind, is to make a mark that we call, from the business side, we call it suggestive. And what that means is you're suggesting to your potential customer what the benefit of your product or service is. And the first one I have listed here is Amazon. And Amazon, when it first came out, their tagline was the largest bookstore in the world. And you have this idea of the Amazon River, the largest river in the world, and you had this concept of an endless flow of books because they would deliver anything. They would ship anything. So when they first came out, they left us all with the impression of a large supply of something. The Amazon River water, but in their case, books. Google did something similar. Google's first product was a very, very, very fast search engine, right? We used to sit around it, type in words, and see how fast they put the time in the quarter, how long it took them to do that search. So Google, which is one followed, it's a real word, one followed by 100 zeros, is a very big number. And all of us techie geeks said, oh, we knew what a Google was, and we looked it up. And then we associated us with this search engine that moved really, really fast, and we had a lot of fun with it. Other made-up words make good trademark candidates as well. I think if you look at Acura, it leaves the impression that it's accurate. So you think of precision engineering, right? So those make good, strong trademarks. Weaker marks are commonly used words, regional things, Napa, Cal, NorCal, things like that. I'm sure the NorCal business people would disagree, but a lot of things have Cal on them, and they aren't all that strong a mark. Here's what is not a trademark. Any generic phrases, like a red car or my cookies. You'll see a lot of businesses that begin with the word my. And I don't know why, because you're never going to build good brand name recognition calling it, my spa or my software company or anything like that. That's used quite a bit. And they're very hard, if not impossible, to get trademark registered because they just don't stick around in the minds of the buying public. And the test for trademark, if you remember, is how the public identifies that trademark with the source of the product or services. So you want a trademark that is unique as you can. And if you're a small business, you want unique, but also one that suggests to the public what it is you do. So trademarks should always be used as an adjective and not as a noun. If you look at a Kleenex tissue box, you'll see it says Kleenex, but it'll always say Kleenex tissue. Kleenex doesn't want you to call it a Kleenex. They want you to call it a Kleenex tissue. And they want you to do that because if a Kleenex becomes a regular noun, then they lose their trademark status. And they did at one time, and they had to work to get it back. So use your trademark as an adjective that defines your product or service. So I don't know exactly how Amazon does it, but Amazon is an online retailer. So they probably have, everywhere they use it, or most places, Amazon online retail, or something along those lines, that says Amazon is the adjective that defines the product of being a retailer. So you want to use your trademark as an adjective and not as a noun. And the last bullet here is, should you use the little TM or the circle R? When you first start using a trademark, you can go ahead and stick the TM on it. TM tells the world that you're claiming this as a trademark, and it gives you some limited amount of rights. Maybe not perfect, and you might have a problem with other people who are using it first, but at least it puts the world on notice that you're using it. Once you go through the registration process, then you can use the little circle R. That means you're registered with the trademark office, and you have a lot more enforceable rights, including the right, basically all the U.S. territories. So even if you're just using it in the West Coast, once you get registered, everybody in the East Coast is now on notice. That trademark belongs to you, and they can't use it. So that's what the circle R is for. You never want to use the circle R until your attorney tells you it's okay, or you'll get in some kind of legal trouble you don't want to have. But you can use the little TM, and you should as soon as you can. The second thing you should do is once you start using a trademark, let's say you're using a slogan or something on your web page, burn off a copy, save an image of that web page, and save the date. Because believe it or not, trademarks go to the first person who uses them, the first company that uses them. And if you can prove you were using it, in January, that might come in handy against somebody who started using it in August. So you want to keep a record of it. So when you first start using your trademark, use a little TM and keep a record of it. The trademark process isn't too bad, but it kind of looks like this. We do an early search, and we prepare it, and we file it. And the trademark office does an examination. And it's possible we can file a trademark under different treaties and give us rights in other countries as well. I won't get into that here, but you should know that if you're thinking about launching your product somewhere else, you want to talk to your attorney about, hey, how can I get protection in Europe or whatever countries you happen to be going through. The trademark office, within about 6 months, will examine the trademark, and if all goes well, moving along the top line, they'll publish it for opposition. And if nobody opposes, they register it, and then 5 years later, you can have a declaration of incontestability, and your trademark will stick around. A trademark lasts for the life of your business, which is good for you because it never expires, so you don't have to do anything. But every 5 or 10 years, you have to file a statement saying, yeah, we are still using it. If there's a problem with your trademark, during the examination process, the examiner will reject it, and you can go and file a response and argue with the examiner on why it should be allowed or why it shouldn't be allowed. So that's a very simple process for a trademark. They don't take long. You'll usually get your trademark in 6 to 9 months, unless somebody files an opposition, which isn't uncommon. You might be surprised. There's industries that look for possible trademark issues and file opposition, representing their clients and having some kind of process that, attorneys can deal with it if you have that happen. But if you think of a really creative name, do a good search, and all probability they'll sail right through and you'll get your trademark. A couple hints on naming your company. A trademark is all your brand equity. It tells the public everything about your company. So if you look at the Nike swoosh, it's really valuable. I mean, if you could put, most of us listening, if you could put the Nike swoosh on your product, you'd be able to raise the price considerably. Everyone would say Nike's a good company. They make good quality products. Everything that company embodies is in that little swoosh logo and in the name Nike. So you want to take a little bit of time on your name, because it's very important in the long run. And like I mentioned earlier, especially in Nike's case, probably the most valuable intellectual property protection you're going to get. So I mentioned Amazon and Google. Suggestive names that emphasize the benefit of your product or service, not the feature. The feature is great for us. We're in the design business, because we see the feature and we think, oh, that's a nice feature to have. But customers don't buy features, they buy benefits. What will your product do for me that the other products won't do? And if you can suggest that, then you're likely to have better results with your trademark and all your marketing efforts, and hopefully more sales. Use syllables, recognizable foreign words, creative spelling. There's a lot of foreign words that come into English quite easily, especially Spanish words, Latin root words, French words, and things like that. And you can always use vino for wine and those type of things. But if you break down the syllable part, then you can broaden it, you can put them together, and have combinations of syllables that say what you want. I mentioned earlier Acura, which sounds a lot like accurate, right? So it was a very good idea to use just that group of syllables to do what you needed to do. The other thing you should do is you should separate the image, your logo image, from the text, so they aren't intertwined. And I got a great example here from our firm. Very early on when we started the firm, one of our friends designed a logo for us, and it's on the left and it's labeled old. And the company's original name was Antero & Torme. So they took a stylized A and a stylized T, and it looked great. And we used it for a little while, and then something happened. We changed the name of the company to Antero, Torme & Petrin. And once we did that, A and T didn't cut it for us anymore, and we had to go to a new logo. So we wanted to have an image that didn't have any letters at all, any words at all. Just like the Nike swoosh doesn't have any words on it at all. Now we have an image that represents our firm that we hope in the customer's mind we can build some type of brand awareness. So the idea that you want an image that is simple to reproduce, looks good on a letterhead, masthead, web page, things like that. I prefer a lot more straight lines than curved lines. Curved lines can be a little bit hard to reproduce, especially if you're doing like an icon on a software product and things like that. Anyhow, you're looking for a clean line, visual, that transfers in the customer's mind who you are as a company. And the reason this is valuable, not just if you change your company name, but it gives you a lot more marketing flexibility. So we recommend that if you come in with a new company name, 2 trademarks, one for your company name and one for your company logo that are separate. And for those of you who fly a lot, there's been a lot of consolidation in the airline industry, and two of the airlines that merged were United Airlines and Continental, and I fly on both of them. So I go to the airport and I see the United label at the airport counter. I see United written on all the planes. I see United written on the advertising. But on the United planes and on the behind the counter and all that is the Continental logo. So what they did was they took the name United and the logo from Continental and they merged them together when they made the new company. So in that process, if you are normally a United customer or normally a Continental customer, when you show up at the airport, you have something that looks familiar to you. You didn't feel like you're going to a new airline. It was a merger of the two, and the merger went very well because the clients saw the logo and the branding that they were used to. So If you go down the road with your company, you may find yourself having a problem changing a name or being forced to change a name if you're, run into someone else's name, or you want to merge with somebody else. And you might want to have the flexibility to ditch your image of your logo from the words of the name of your company to change the company name. So do your logo and do your text separately when you go and do your trademark filings. Last big topic is what is a patent? And the U.S. Constitution allows the government to issue patents and actually copyrights. And a patent can cover a process, and this is how we include software. Usually, there's been a lot of court activity on limiting the ability to do pure software patents. So normally we do them as business methods, and we normally do them usually tied to a piece of hardware. The court's a lot happier if we have a piece of hardware there because they have, unfortunately, justices aren't software developers or engineers, and they don't like this idea of an electrical signal being patentable. So they like to have it tied to a machine, which is the second one, a processing device. Anything you build or some composition of matter, you might be able to come up with a new way of making hardened steel or something along those lines. That's all the type of material that can be patented. Here's what patents do. They provide a defensive right allowing you to prevent someone else from making it. What they don't do is provide you with the right to make it yourself, which sounds a little bit weird. And to think about what situation you have. And the example I use is a bar stool. If you had a four-legged bar stool and you got a patent on it and you're selling bar stools, good for you. If I come along and I say, this four-legged bar stool would be better if it had a backrest and armrest. So I patent a four-legged bar stool with a backrest and armrest. Now I have a new product, but included in that product is the material from the first patent, the four-legged bar stool. So I have a patent that lets me stop anybody from making a four-legged bar stool with an armrest and a backrest. But it doesn't give me the right to make it because when I do, I'm infringing the earlier patent. Likewise, the guy that has the earlier patent, the four-legged bar stool, he can't add a backrest and an armrest to it because I have a patent on it and I can stop it. Now, in the real world, you'd probably work together to get around this. But if you're patenting an improvement to another product, there's a real chance that even though you get the patent, you might not have the right to make it. So what a patent does is it gives you the right to go to court and stop somebody else from making or using that invention, but only the one that your actually patent covers. So, and that distinction is very important because when you're running a small business, people think I want to patent my technology. Well, that's true. But you also want to patent what your competition may do. So if you know other ways to do it, you want to patent that as well because that allows you to stop competitors from getting close to you. So if you have a great idea, we want as much protection, as coverage as we can get because the goal is to stop the competition more so than to give you the right to do. Now, if you can stop all the competition, you're going to have a very nice, sustainable competitive advantage. So the best patents are on core technologies. Not small improvements or mere better ways to do it. What you're looking for is some technology that you do that really is, we say straw in the goal. It really is the type of thing that turns heads. You can get a lot of patents on smaller improvements, but what you're really looking for is the core technology that makes everything go really well. That's the type of thing you want to patent. But before we get too far into patents, one of the requirements is they have to be new. And I always suggest to my clients that they do a quick search. Google has the patent database online. The Patent Office, uspto.gov, they have the patent database, but it's not very user-friendly, whereas Google does a pretty good job on it. You can use all your standard keywords and things like that. And they update it, I think, every Tuesday, the Patent Office prints results. So it's reasonably current, although every now and again, I'm surprised that a patent that I know should be there is not there. So it's not a perfect search. The other thing about patents is they can be kept unpublished. So there may be a patent pending that you don't see because normally they don't publish them until 18 months after they're filed. And if you pay a fee or you make a deal with the Patent Office, they might keep it hidden forever. So you don't have a guarantee that the patent will actually be available if you do a search. Which means patent searching, although it's important, it's not critical if you don't find it because it may still be secret. It may still be unpublished yet. The second thing about novelty is just because it's not commercially available doesn't mean it's not known. I think 1 week I had 3 separate inventors come to me and they had an invention to stop shopping carts from rolling into cars, and which sounds like a really good idea. And I did a search on it, and there's probably 20 inventions to stop shopping carts from rolling into cars, right? It turns out it's a type of problem everybody sees and says, I think I can solve that problem. But they're not commercially available. And the reason they aren't commercially available is because the shopping centers can put up a sign that says, we're not responsible to damage to your cars. And because they're not responsible, why would they spend the money on having a smart shopping cart? So it turns out that it's a classic example of the solutions, or a lot of solutions, are well known, but it's not commercially available. So you'll often hear people say, I've never seen it done before. Well, I've never seen it done is not a patent search. You really want to take the effort. Go to Google, search around for it. The second reason you want to go to Google is if somebody's doing it, well, you'll save a lot of money not paying a patent attorney. But if you're going into the business or you're in that business already, you want to know what's out there. You want to know what your competition is doing. And a quick search of the patent database can give you a lot of information on what your competition may be doing. And there's a whole intelligence community around analyzing patent filings for different entities and just try to get a hint about which direction they may be heading. You'll often see newspaper articles on Apple's patents filings and things like that that give up where they might be heading, or at least some indication of where the company might be heading. So first thing is novelty. Do your own search. Go a long way for you and for your business. Second test is, in the United States, we need to know who invented it first. The patent goes to the first inventor to file a patent application. Not the first inventor anymore, but the first one who actually files the patent application, assuming they're independent inventors. However, with that said, you have a year from when you first use it publicly or offer it for sale to file a patent. So for the smaller clients we have that are really cash-strapped and they're willing to take the risk, we say, why don't you go see if you can sell it? If it looks like it's going to sell, come back. We have a year to file for a patent. Now, the risk is that somebody else will file for that patent first. But if they don't have a lot of money, their money is probably better spent marketing their product than it is filing a patent, right? Because you want to get on the market, find out if it's viable, and if you sell a lot in the first year, that's okay too. If you're already selling, that may be a bar from somebody coming behind you and patenting it as well. So you want to talk over. That's one of the trade-offs dealing with attorneys you want to talk over. So there's a thing called a provisional patent application. We recommend using a lot of them. There's a lot less formalities. You can put several inventions together if you do it right, if they're somewhat related. And they cost about half the price of a regular patent. So what a provisional patent application does is it gives you patent pending. You actually file the application, but it's not a complete application. And within a year, you have to go to the patent office and file the rest of the application. Usually the legal claims, provisional applications, you can use hand drawings, you don't need formal drawings, things like that. So provisional applications, if you're a very creative group, you want to have a lot of provisional applications. And some of our clients, what we do is we sit down every now and again with the engineers, and we have a little invention workshop, and we talk about all the things we should be patenting. We file a whole stack of provisional applications, and then over the course of the year, the engineering managers and I will sit there and say, okay, does this look like it's something we're spending money on? We'll go ahead and proceed with it. Otherwise, we'll let it go. The second thing about provisional applications is that they never become public. They only become public if you patent groups, so people don't get to see them. So if you have an idea and you just want to go check it out, you can file for the provisional patent application. You have a year to work on it, and if you don't get around to working on it, you can just file it again. Until you finally do get around to working on it. So now you lose the earlier filing date, but if it's the type of thing that you really are creative and it's really new to you, it's not going to be public, and so you can actually keep filing provisional on the same thing over and over again until you finally get around to make it a reality. So as far as what's required, you don't need to build the invention and you don't need to make a prototype. What you have to do is provide enough instruction so that a skilled artisan can make the invention for you. Now, I'm an experienced software developer, so you tell me how to do it, and I've pretty much everything I need to write the patent application. We like to use drawings, flowcharts, things like that, and that's usually sufficient modernly to describe an invention because the flowcharts will tell you everything you need to know about how to do it, and most of the tools are pretty standard now. But you don't need to wait until you invent the perfect whatever. Usually, when you're doing your product development, there's the hard part, the part that took you a lot of effort to get to. That's really what you want to protect. And once you get that figured out, you probably want to apply for provisional application. And we don't need the whole working product. We just need to know how to make it, and we can get that from your drawings. A couple more things on provisional patent applications to remember. They're utility patent. There's different types of patents. One of them is called the design patent, but these are utility patents. Design patents cover the ornamental look of a product, and I think we'll talk about that later in the presentation. Once you get a provisional patent filed, you can say it's patent pending. And like I mentioned earlier, if investors are looking at your product or service, they don't want to sign a non-disclosure, you can relatively affordably file for a provisional patent application, get patent pending on it. Since it's already in front of the patent office, the investors aren't worried that they'll be accused of stealing it, and they'll go ahead and look at your business idea. They never get examined. You can enhance them a little bit within that year period. If you find this, you want to add a little bit to it, you're allowed to do that. And like I mentioned, they aren't made public. Patent applications are property. They're not real property, but they're like real property. A patent application can be bought and sold and licensed. So it's not uncommon for inventors to file for a provisional patent application and then license it to somebody that they hope will build a product. So once you get that filing information, you have a real tangible thing. Once you get patent pending, you can try to sell it. It's hard to sell a patent application that you haven't really developed yet. So if you have a good working model, that patent application will be a lot more valuable because people will see what it is you're doing. If you have paying customers or a bunch of customers, then your patent will be even more valuable because you'll be able to show to the person who wants to buy your patent that it is in fact viable, that this is a good idea and people are doing it. And finally, a little memorization. They stop others. They don't authorize you to make, and you got to keep that in mind because that's the whole essence of patent strategy. Keeping in mind what they do for your business. Internally, you want to have some process to identify patentable material. For a lot of young companies, especially out in high-tech startup out here in California, people have great ideas and they leave with them. Right? You want a way to harvest those ideas and get them into your company. So you want to have periodic design reviews and ask yourself, is this patentable or not? And have some process to determine if it's patentable. Maybe it's better to keep something a trade secret. The law changed recently in 2014 to give trade secrets a lot more protection. And one of the things that you can keep a trade secret is part of your software. In the old days when you distributed code, even object code, executable code, people could reverse engineer it. It was very easy to do, and that literally all the way back to regular source code, and then copy it. So you couldn't keep it a secret. But now everything's up in the cloud, so it's possible that you can have your secret sauce data engine removed from the public eye so that the actual calculations, the artificial intelligence, or whatever it is you're doing are not exposed to the public where they can get at it. They can see the results, they can see the input, and they can see the output. But they can't figure out how you got from input to output. And that might be a much better trade secret than trying to patent the software. So keep that in mind, of merging the trade secret in with the patent world. Can you keep it a secret? And if you can, it's probably better protection. If you can't, you're probably going to have to apply for a patent. You should apply for patents before any public use or sale. In fact, in Europe, that's one of the requirements. In the United States, we have a 1-year grace period. There's a couple patent strategies. There's defensive, offensive, and licensing. Basically, defensive, you want a patent on what you do because it'll keep people from suing you, hopefully, because you're in the realm of what you legally own. Offensive is used when you want to attack the competition. And I mentioned earlier that you want to patent not only how you do it, but you want to patent all the other ways it can be done. So when a competitor shows up, you may have a patent on what they're doing, and you'll be able to stop them and keep all the competitors at bay. In small industries, it's not uncommon for the big players to just cross-license to each other because they know each other and they kind of infringe each other's patents all the time. And instead of suing each other, what they do is they cross-license each other's patents and they go after anyone new who shows up in the industry. So you'll see a lot of patent cross-licensing activity if you read the trade journals on it. So, little IP legal advice. If they have access to your secret, make sure you get a signed non-disclosure agreement from them. Get a signed invention copyright assignment agreement from all your designers and engineers, including your contractor. One scenario, imagine a logo designer that you hire him to, I guess we're running into a little bit of time. Okay, you hire a logo designer as a contractor, and the contractor gives you the logo, but you don't have any signed agreement. That contractor comes back years later and says, hey, that logo's my copyright, and you don't have any agreement. And then you're going to have a lawsuit on a logo. So you want to watch out who's an employee, subcontractor, or other, and make sure they, in fact, hand over the intellectual property in a written agreement to your company. You can sell it or license it. You should consider franchising, because franchising, fundamentally what a franchise is a license to use your intellectual property. So if you want to franchise a Subway sandwich store, what they're saying is you can use our brand name, Subway, and our recipes, and even our material, and in exchange you pay us a fee. Now they put in some kind of quality control and things like that. But franchising is a great way to grow a business fast, because all you have to do is provide the trademark information, usually, or some type of intellectual property. And finally, IP portfolios please the investors. You know, they're usually one of the first questions investors ask, have you applied for any patents? And you'd like to say, yeah, we have patents on this, that, and the other thing. Or we've applied for patents on this, that, and the other thing. And that was very, very beneficial in your fundraising activities. So that's the last slide I have, and I think we can do questions. I think Matt's going to run that. There's a little picture. A lot of the stuff we covered, I have a very small book. It's available online. You can pick it up on Amazon for startups, very early stage protection. It's a very easy read, covering a lot of the material that we just covered right now. So how are we doing the questions, Matt?
All right, Pete, 1 second here. All right, everyone should have been given a prompt to ask a question. I know I had a few people post in a few questions prior to the Q&A starting, so Pete, maybe we can start with those. Is that okay with you? Sorry. Sorry, Pete, I had you on mute there. Did you get that, Pete?
Yeah, it'd be no problem if you want to go ahead and fire away.
All right. Well, I'm going to go back to the first question I had here from earlier from Ken. I don't know if he's still in line with us. I believe he still is. But he had a question back when you were talking about trademarks. And the question was, what do you think of Tesla Motors as a trademark? That was one question that he had there. I'm not sure if that question...
Yeah, it's an easy question to answer.
It's
it's a famous brand name now, and Tesla was a famous person, but he's a person out of history. And I don't know if their trademark is just Tesla or Tesla Motors, but they've done very well with it. It's a household word. And, of course, if your idea is to build brand equity, Tesla Motors has done it. There's no doubt about it. So, yeah.
Great. Hopefully that answers the question.
Yeah.
Yeah. Okay, great. So next question here looks like is coming from Dan. Dan is asking, what should hardware companies that manufacture in China do about IP protection there, especially patents and trademarks? Might be a long question here.
Yeah, well,
long answer, I mean.
Yeah, well, I'll try not to make it a long answer. I realize I went a little over, trying to pack too much, I think, into the 45 minutes. But the same rules apply. You want to apply for a patent if it's a physical device and you think that it's the type of thing that is in fact patentable. And the reason you want to do that is you can stop knockoffs on the border on the way in. And trademarks the same thing. The question is how protectable that trademark and patent is in China. And my understanding about the Chinese intellectual property arena is that the courts over there have gotten stronger. They've basically had a lot more Chinese inventors, and so the courts have done a better job trying to protect that intellectual property. However, if you're making, and you know this probably better than I do, if you're making it overseas, you want to have some type of exclusivity agreement that they aren't going to sell it anywhere else in the rest of the world. But certainly you want the same protections you would if you were in the U.S. market.
Great. I'm sure you can probably go into more detail on that, and they probably can reach out to you. Yeah, they probably can reach out to you, obviously, if you want some more advice or to seek counsel on that. So next question I have here is from Mohammed. And his question is, if I have an idea for an application which is not related to my current job, can I file a patent about it outside my company?
The answer to the question is probably yes. I actually just wrote an article on the company webpage, if you go to antlegal.com, where I discuss the pros and cons of it. And the answer, it's not clean. Generally, if it's outside of what your company's doing, they have no claim to it. If you're in California, the law is very specific. They can't make a claim to it. However, if you're a researcher or a product designer or something like that, in all probability, your employment contract is going to say you have to give that invention to us. So you have to look at your employment agreement, make sure you're in the clear, and if you are, you should have no problem file for patent on it or trying to build a business on it. So you just got to make sure that your employment agreement doesn't get in the way of you leaving with that idea.
Perfect. Hopefully, Mohammed answered your questions. I have a second question here coming in from, next question from this guy, Alex. I'm going to take the question here, and I'm going to let Alex take the floor here. Alex, if you can hear me, Alex?
Yeah, I can.
Okay, great. I just took you off mute here, so you can go ahead and ask your question.
Yeah, so I have an issue with a CEO. I was wondering, can I create a modification of a product even though the product is patent pending?
Absolutely. The test is, are you the inventor? I'm assuming you are because you have a new modification. And you can apply for a patent on that modification yourself. You're the inventor and you're entitled to a patent on it. So
now, if I wasn't the inventor, obviously I cannot do that, right?
That's right. Patents only go to the inventors. They issue in the name of the inventor, even though the company may own the patent. So like I said, they come out in the name of the inventor, but you can transfer the ownership even before they're actually applied for.
So even though it's a different product, is that fall under the same jurisdiction, or?
Well, I'm not sure what you mean. If you make an improvement to an existing product, that improvement is patentable in its own right.
For instance, if it's a significant improvement in which it was like completely redesigned, but it does a similar function.
Yeah, well, like I mentioned earlier, just because it does a similar function, your expression, your manifestation of how you did it is patentable. And if it's different enough, it's distinct, then it's patentable. The question is technological, how different does it have to be? And that's really a judgment call.
Who makes that judgment call?
Well, what we do is we advocate for you, but ultimately the patent examiner makes that judgment call.
I see. Okay, so I could essentially create a new product based off of an original idea, but it has to be different enough that it can be patentable.
That's right, exactly.
I see. Okay.
Thanks, Alex. Appreciate that question. I'm going to go ahead and take you off mute here and get to the next question. Thank you very much.
Thank you.
Yeah. All right. Pete, I'm going to let Ken here take the floor. He has a question for you. Ken, can you hear me?
Yeah. Pete, I wanted to go back to the Chinese copycat manufacturing area. Do you have any idea about enforcement kind of at the source before manufacturers start to copy your design that's been patented? And does it have to be patented in China as well to prevent that? And kind of how much it would cost. That's really kind of what I'm looking for.
Okay, yeah. That's a little tougher question because you never know how much any legal activity is going to cost you. You know how hard the other side is going to fight, right? But the Chinese courts aren't going to enforce a U.S. patent, so you're going to need a Chinese patent to do it. However, the good news is in the United States is you can actually enforce patents at the border with U.S. Customs officials. So there's a way to bring an action if you know it's coming. That helps a lot. To actually seize the product. So you can do that. That's one way to grab it at the border. The other way to do it is that supply chain, if they have an infringing product, is to go after everyone in the supply chain. So it's not just the manufacturing company. You can go after the people who brought it in to the U.S. market. So usually retailers don't have a lot of patience with patent lawsuits. So they're gonna, if they can change the product out and go with somebody else, they're likely to do that. So, does that answer your question?
Yeah, but you get into these weird situations like hoverboard, right? There were just hundreds of knockoffs of that product.
Mm-hmm. I don't know the details of hoverboard, but I suspect what happens is it's a fairly large, fairly complex product. So they probably patented certain technologies, but not necessarily the whole hoverboard idea in its own right. And if they have a patent on the whole hoverboard and all the way it works, then either these people found a way around it, or they need to step up their game enforcing it, because it sounds like they're leaving a lot of money on the table.
Okay, thanks.
Sorry, I couldn't give you a better answer than that. So.
Perfect. Thank you, Ken. I'm looking here, and it looks like no one else has a question here. So if anybody else has a question, it's time to ask. Other than that, just a really quick announcement to everybody who's still on the call. This presentation was recorded, and we reproduce all of our webinars and live events and republish them to the Hardware Massive Resource Center. I'm going to put a link into the chat box over here. So this presentation will most likely be available within a couple of weeks, so it's less than 2 weeks. Let's take some time to re-edit the video and then get his presentation and then put some key takeaways from it up on the platform. So just hold tight. It will be available. Just look for that in the Resource Center. Here's a link coming in right now. So just hold on to that link and go over there. There's also a bunch of other great resources from other prior webinars and live events from all over the world in all of our 33 chapters. So yes, that's what we have going on here. So if there's any last questions, now's the time. Other than that, that is all we have for tonight. I really appreciate Pete coming out and giving a wonderful presentation. So yeah, so Pete, any last words for the community here who's still left online?
No last words. Thank you so much for giving me a chance to talk about such a great topic, something I like.
Wonderful. All right, guys. Well, have a good night, and we hope to see you at a future event here at one of our chapters around the world. And any questions, go ahead and just shoot me an email. It's matt.hall@hardwaremassive.com. And other than that, have a great night, and I guess also a great weekend ahead of you guys. And thank you again, Pete.